Good morning. In case you missed it, the title of my last video where I mea culpa'd to Blue Bacon was somewhat tongue-in-cheek. I obviously did not mea culpa to Blue Bacon. So if you didn't figure that out, now you should know. Now you should be aware. Another thing that is popping up, and I'm surprised, is why we can't use the other definitions of installation that Blue Bacon wants to use. And people aren't understanding it. And I've given them the complicated answer, but perhaps I was negligent in ignoring the elephant in the room. The elephant in the room is that the statute itself, 18 U.S.C. 795, gives the power to define what a vital military or naval installation or equipment is to the president. It's the very first sentence where the legislative branch grants the power to make that definition to the president, and the president doesn't relinquish the entire definition. If you go to Executive Order 10104, which is where the president defines what a vital military, naval, or Air Force installation or equipment, he defines what it is. He gives the power to change the classification, designation, or marking to the Secretary of the Army, etc. But he doesn't give them the power to otherwise alter the executive order. And the executive order spells out the definition. A installation has to be located within a base, etc. He did not give the Secretary of the Army the ability to modify that portion of the definition. So we have to use the definition that's provided. We have to use the whole definition that's provided. We can't ignore the inconvenient parts of the definition that's provided. No matter what Mr. Bacon wants to say, the Secretary of the Army does not have the power or the authority to change the definition of an installation. He has the power to change the classification, designation, or marking of an installation, but he does not have the power to change the definition for 18 U.S.C. 795 of an installation. He was not delegated that power. He doesn't have that power. It just doesn't work that way. So that's the elephant in the room. Everything else still stands that I said. It has to be read internally consistent. You have to deal with the within. It doesn't make sense to read it installation within installation. It doesn't make sense to use installation to mean the exact same thing as sections A through F. Why list all of those out if you could just say an installation is all these things? Why would you have to say it's within them? You know, it just doesn't make sense. So you got to read the statute as though it makes sense. Another thing that I did notice is that Mr. Bacon still thinks that Ward versus Rock against racism applies. He still doesn't understand what content neutral is, at least from the comments that he's making on his video. Content neutral is, again, the most important aspect of that particular test. You do not get to time, place, and manner restrictions. Nothing else. You don't pass go if it's not content neutral. Time, place, and manner restrictions only apply to content neutral restrictions. That's it. So that is still a big kicker right there. I think that'll do it for today. If anybody has any questions, obviously, you know, I do love to talk about this subject matter. Does he have me riled up? No. Do I enjoy this? Do I get excited over it? Sure. Was I all eager to get home once I started listening to his video on my drive home? Yes. Did I speed a little bit? Probably. But it's fun, and I enjoy the conversation, and I enjoy the dialogue, and I hope people are learning from this. I doubt Mr. Bacon is. He's going to be entrenched in his position because, well, some people do, but that's fine. You know, he seems to think that he has more compelling reasons than I do while ignoring the actual text of the statute. Good on him. Thanks for watching. Have a great day.